There are cases that change the people who witness them, not because of dramatic speeches or explosive confrontations, not because someone famous was involved, or because the stakes were unusually high in a legal sense, but because of what gets revealed in the process, about systems, about people, about the particular cruelty that can live inside ordinary-looking paperwork. This is one of those cases. The man at the center of it was 58 years old. He had served 2 tours of duty overseas, come home with injuries that weren't all visible, and spent the better part of a decade navigating a life that had not made room for him the way he had once believed it would. His name was Daniel Pruitt. He had slept in a shelter for 11 months before a housing assistance program placed him in a small subsidized apartment on the edge of a city that had no particular reason to remember him. He was being told he owed $12,000 to a debt collection agency that had purchased his account from a housing authority he had never heard of in a city he had never lived in. And if you are already wondering how that is possible, then you understand exactly why this case ended the way it did. To understand what happened to Daniel Pruitt, you need to understand how certain kinds of debt are created, sold, and collected in this country. When a person falls behind on rent, or is alleged to have fallen behind, or is recorded as having vacated a property under disputed circumstances, that debt, real or not, often ends up in the hands of a housing authority or property management company. If it goes unresolved, it can be sold. Debt purchasers buy large portfolios of these accounts for a fraction of their face value, and they then pursue collection on the full amount. The profit margin depends on volume. The accuracy of the underlying records depends on nobody in particular. This is a legal industry. It operates at scale, and the people it tends to target are people who are least likely to have the resources or the knowledge to dispute what they are told they owe. People, in other words, like Daniel Pruitt. Daniel had been notified of the debt by a letter that arrived at his subsidized apartment, ironically, the one stable address he'd had in years. The letter was from a company called Meridian Recovery Solutions. It stated that he owed $12,240 in unpaid rent and damages to a property at an address in a city 4 states away. The debt was allegedly from a tenancy that had ended, according to the letter, 7 years ago. Daniel had never lived at that address. He had never lived in that city. He had been deployed overseas at the time the alleged tenancy had supposedly begun. He read the letter 3 times. Then he set it on his kitchen table and sat across from it for a long while, the way a person sits with something they cannot yet fully process. He had dealt with bureaucratic systems his entire adult life, military, VA, housing assistance, and he knew, in a way that only experience teaches, that being right and being believed were 2 very different things. He asked the shelter's case manager for help. She referred him to a legal aid organization that assisted veterans with civil matters, and that organization assigned him an attorney named Kwame Asante, who would prove to be one of the more important people in Daniel's life that year. Kwame Asante had been practicing civil law for 14 years, with a concentration in consumer protection and housing. He was 39, methodical by nature, and had worked enough debt collection cases to recognize, within the first 30 minutes of reviewing Daniel's situation, that what he was looking at was not simply an error. It was a pattern. The debt had originated with a housing authority in a mid-southern state. The account had been sold twice, first to a regional collections firm, then to Meridian Recovery Solutions. Each transfer had moved the account farther from any verifiable documentation of its origins. By the time it reached Daniel, the file contained a name, a social security number, and a dollar amount. The address on the original account was different from any address Daniel had ever been associated with. The dates of the alleged tenancy overlapped with a period during which Daniel's military deployment records placed him conclusively overseas. This was not a case of disputed amounts or contested damages. This was a case of a debt attached to the wrong person, or, more precisely, a debt that appeared to have been attached to a person who shared a name with someone else through a chain of transfers that had never been required to verify its accuracy. Kwame filed a formal dispute on Daniel's behalf with Meridian, attaching the deployment records. Under federal law, a debt collector receiving a dispute is required to investigate and verify the debt before continuing collection activities. Meridian's response came 22 days later. They affirmed the debt. They did not provide verification. They did not address the deployment records. They did not explain the discrepancy in the address. They simply restated that the balance of $12,240 was valid and due. Kwame filed suit. The hearing was held in federal district court before a magistrate judge named Honorable Patricia Duvain. Judge Duvain had spent 11 years on the federal bench following a career in consumer law. She was precise, unhurried, and possessed of a quality that experienced attorneys recognized quickly. She read everything, not just the top-line summaries, not just the briefs, everything. And when she asked questions, they were rarely clarifying questions. They were the kind of questions that demonstrated she had already identified the problem and wanted the person responsible for it to demonstrate whether they had too. Meridian Recovery Solutions was represented by a man named Gerald Stroud, a collections attorney who handled a high volume of these cases and whose manner in court reflected that volume. Efficient, slightly bored, accustomed to proceedings that moved quickly in his favor. He was not accustomed to Judge Duvain. Daniel Pruitt sat at the plaintiff's table in a collared shirt that Kwame had helped him press the night before. He sat very still. He had, over the past 8 months since the letter arrived, moved through a range of emotional states: confusion, anger, exhaustion, a particular kind of weariness that comes from being asked to spend significant energy proving you are not who someone says you are. He had arrived, by the morning of the hearing, at something quieter than anger, a kind of resolve, the expression of a person who has been waiting for the room where this gets settled. The opening was procedural. Judge Duvain reviewed the filings, confirmed the parties, established the basic facts of the dispute. She asked Kwame to summarize the plaintiff's position. Kwame was concise. His client had received a collection notice for a debt he did not owe. The address associated with the debt did not match any residence his client had ever occupied. Military service records established that his client was deployed overseas during the period the alleged tenancy was supposed to have begun. A formal dispute had been submitted with this documentation. The defendant had failed to provide verification and had continued collection activity in violation of the Fair Debt Collection Practices Act. Judge Duvain made notes. She asked Stroud to respond. Stroud's response reflected the standard posture of a collections firm that has been challenged. The debt had been acquired through standard industry processes, the documentation provided had been reviewed internally, and the firm stood behind the validity of the account. Judge Duvain looked at him over her reading glasses. "You stood behind the validity of the account," she repeated. "Yes, Your Honor." After receiving documentation placing the plaintiff in a different country during the period the account was allegedly created. "Our internal verification process. I'd like to understand that process," she said. "Walk me through what your internal verification entailed after you received Mr. Pruitt's dispute." Stroud began a description of standard industry protocol. Meridian had cross-referenced the account with the information provided and found no basis to invalidate the debt. "What specifically did you cross-reference?" A pause. "The account records provided by the originating authority." "Which records?" "The name, social security number, and account history." "Did you verify the address associated with the original tenancy against any address ever linked to the plaintiff?" A shorter pause this time. "Our review process. Did you check whether he had ever lived there? Yes or no?" "I would need to confirm with our compliance team." "You're in court today representing that this debt is valid," Judge Duvain said. "Surely your compliance team has already confirmed the basis for that position." Stroud said he would need to request a brief recess to consult his records. Judge Duvain said he had 30 minutes. Daniel Pruitt sat in the hallway during the recess. Kwame sat beside him, and they didn't talk much. There wasn't a great deal to say. The situation was what it was, and they had done what they could do, and now they were waiting for the system to move at the speed the system moves. Daniel had a cup of coffee from a machine down the corridor. He held it in both hands, even though it wasn't cold. He had a habit, developed over years of early mornings in situations where waiting was the primary activity, of holding on to something warm. He told Kwame, during that recess, something that Kwame would later describe as the clearest articulation he had heard of what this kind of case does to a person. Daniel said, "I've spent my whole life trying to be someone they couldn't say anything bad about. I followed the rules. I did what I was supposed to do. And this letter comes, and it says I owe $12,000, and suddenly I'm supposed to prove I'm not a person I've never been. I'm 60 years old in 2 years, and I'm sitting here proving I didn't live somewhere I've never been." He drank his coffee. "I just want someone to read the papers and say it out loud," he said. That's all. When court reconvened, Stroud had conferred with someone by phone during the recess. His posture had shifted slightly, not dramatically, but enough. The slight boredom of earlier had been replaced by something more careful. He informed Judge Duvain that, after consultation, Meridian was prepared to acknowledge that the verification process in this specific case had been insufficient. He began to move toward a framework that suggested the firm might withdraw the claim without a formal ruling. Judge Duvain stopped him. "I appreciate that," she said, "but I want to make sure I understand what happened here before we discuss resolution. You've acknowledged insufficient verification. What does that mean specifically?" Stroud said that the documentation provided by the plaintiff had raised questions about the account's accuracy that warranted further internal review. "It raised questions," she said, "or it answered them." Stroud was quiet for a moment. "Mr. Stroud, a man sent you records showing he was serving his country overseas during the period you are claiming he owed rent on an apartment he apparently never lived in. Are those records consistent or inconsistent with the debt you've been pursuing?" Stroud said the records appeared inconsistent with the account. "Appeared. Were inconsistent," he said. "Thank you," she said. "And when you received those records 8 months ago, this conclusion was reachable then?" He did not answer that directly. He said that the internal process had not flagged the inconsistency in the initial review. "Your internal process," Judge Duvain said, "received documentation showing that a man was deployed overseas and responded by affirming a debt he could not have incurred at that time, in a city he has never lived in, at an address he has never been associated with. Is that an accurate summary?" Stroud said that was a characterization he would not entirely. "Is it factually accurate?" A long pause. "Yes," he said. "Factually, that is accurate." The ruling that followed was not long. Judge Duvain did not deliver extended speeches. She was not that kind of judge. But what she said was precise enough that it required no elaboration. The debt was invalid. The claim was dismissed in its entirety. Daniel Pruitt owed Meridian Recovery Solutions nothing. Beyond the dismissal, Judge Duvain awarded statutory damages under the Fair Debt Collection Practices Act for the continued collection activity following a properly submitted dispute. She awarded attorney's fees. She noted, formally and for the record, that the defendant's verification process, as described in testimony, did not constitute a good faith investigation under the statute's requirements. And then she did something that was within her discretion and that she had clearly been considering since before the recess. She ordered Meridian to provide, within 60 days, a full accounting of how the account had been associated with Daniel Pruitt's name and social security number, including documentation of the original account, the chain of transfers, and any other accounts in their current portfolio that had been acquired through the same originating source. She did not use the word fraud. She did not make any finding beyond what the evidence before her required. But the order she issued made clear that she believed the matter extended beyond one wrongly assigned account, and that the appropriate way to address that belief was through documented disclosure rather than assumptions. What the 60-day accounting revealed was not adjudicated in that courtroom, but it was referred, and referrals have consequences of their own. Daniel Pruitt received his damages award by check 6 weeks after the ruling. He did not receive a large amount. Statutory damages under the FDCPA are capped in ways that do not make plaintiffs wealthy, even when violations are clear. What he received was enough to cover several months of expenses, to replace a winter coat that had been with him through too many winters, and to put a small amount into savings for the first time in years. He received something else too. A letter from the VA regional office arrived approximately 2 months after the hearing, informing him that his disability rating had been reviewed and that a recalculation of his benefits had resulted in an increase in his monthly payment, an adjustment that should have been made several years earlier but had been delayed in the review queue. The timing had nothing to do with the court case. These things are not connected. But they happened in the same season of his life, and Kwame, when he called to tell Daniel about the judgment check, heard something in his voice that had not been there 8 months earlier. Not happiness exactly. Something quieter than that. The particular sound of a person who has been told, in 2 different ways, that they are not as invisible as they had begun to believe. There are several things worth understanding about what happened to Daniel Pruitt that are not unique to him. The debt that found him had been purchased as part of a portfolio of several hundred accounts. Kwame learned this through the discovery process. Of those several hundred accounts, the accuracy of each individual one depended on the accuracy of the original Housing Authority's records, which depended on the accuracy of the records before that, going back through each transfer to the original source. At no point in that chain was any individual entity legally required to verify that the person named in each account was actually the person who had incurred the debt. They were required only to verify, in a general sense, that the portfolio they were purchasing contained what the seller said it contained. This is not a secret. This is how the industry functions. And the people who fall into the gap it creates tend to share certain characteristics: limited access to legal assistance, limited documentation of their own housing history, limited familiarity with their rights under consumer protection law, and limited reserves of time and energy to spend fighting something that seems, from the outside, designed to outlast them. Daniel Pruitt had documentation. He had his deployment records, his service history, his VA file. He had, without knowing it, built a paper trail that would eventually save him. But not everyone does. Kwame had taken on 4 similar cases by the end of that year. In 2 of them, the documentation was clear, and the outcome was similar to Daniel's. In 1, the documentation was incomplete, and the case settled for a reduced amount that was still money the client did not owe. In the 4th, the debt had already been attached to the client's credit report, had affected his ability to rent an apartment, and had contributed to a period of housing instability that had cost him his job. By the time the legal process began, the harm was already done. The case was won. The debt was removed. The job was not recovered. There is a version of Daniel's story that ends differently. If the letter had arrived 2 years earlier, when he had no fixed address, no case manager, no referral path to legal aid, if it had arrived when he was still in the shelter, or before the shelter, or on the street, it would have been a different story. The debt would have existed on paper, real to every system that processed it, attached to a name he recognized, and he would have had no way to fight it. This version of the story, the version that exists in courtroom records and ends with a dismissed claim and a statutory award, is the version where everything worked the way it was supposed to, where the legal aid organization was funded and staffed, where Kwame had the capacity to take the case, where the judge read the documents and asked the questions that needed asking. It is worth understanding that this version is not the default. Daniel Pruitt still lives in his subsidized apartment. He's been there 2.5 years now, which is the longest he has lived anywhere since before his first deployment. He has a neighbor, a woman in her 70s who grows herbs on her balcony and occasionally leaves him basil because she grows more than she uses. He has a small television and a library card. He walks to the VA clinic on the second Tuesday of every month. He does not think about the case constantly. He thought about it intensely for about a year, and then it became part of his history, the way most things eventually do, and receded into the background of the ordinary. He told Kwame at their last meeting that what he remembered most was not the ruling, not the check, not the moment Stroud admitted in court that the records were inconsistent with the debt. What he remembered was sitting in the hallway during the recess, holding his coffee, and saying out loud what he had needed to say for 8 months, that he had followed the rules, that he had done what he was supposed to do, that he just wanted someone to read the papers and say it out loud. And then someone did. Judge Duvain read the papers. She said it out loud. She said it in language that carried legal weight and went into a public record and will exist in that record long after the hearing itself has been forgotten by most of the people who were present. That is not a small thing. Courts are slow and imperfect and inaccessible in ways that matter deeply. But a public record is permanent in a way that informal acknowledgement is not. The dismissal exists. The finding of insufficient verification exists. The order for accounting exists. Those documents sit somewhere in a federal filing system alongside Daniel Pruitt's deployment records and his dispute letter and Meridian's response affirming a debt that was not his. They sit there as evidence of what happened and what was decided and what was found to be true. A man who served his country was told he owed $12,000 for a life he had never lived. He kept his records. He found someone who knew how to use them. He sat in a courtroom and waited for someone to read them carefully. And when that person did, when Judge Duvain looked across her bench and asked the question that had needed asking for 8 months, what came out of that process was not dramatic. It was simply accurate. And accuracy, for a man who had spent a year being told a false story about himself, turned out to be the most important thing in the world: $12,000. To Meridian Recovery Solutions, it was one line in a portfolio of hundreds, a number assigned to a name, a collection target in a spreadsheet that no individual person at the company had assembled from personal knowledge or direct experience. To Daniel Pruitt, it was a threat to the small, hard-won stability he had finally built for himself after decades of service and struggle and finding his way back from places that had taken more from him than they had any right to take. The distance between those two realities, between the administrative and the human, is where this story lived for 8 months. A courtroom closed that distance. Not perfectly, not permanently, for everyone it touches, but for one man, on one Tuesday morning, in one federal courthouse, the distance was closed completely. He went home afterward on the bus. He sat by the window. He watched the city go past. And for the first time in a long time, none of what he saw belonged to a story someone else was trying to tell about him.